Something in Elizabeth Sider's competency filing jumped out at me almost immediately. Not because of what her attorney was asking the court to do, but because of the words he used to explain why he was asking. And once I put that filing next to Gary Siders Jr.'s, I went back and read it again. Hi, everyone. I'm Stina, and this is Motive and Method. If you're new here, I hold a BA in communication and have more than 25 years of professional experience in written and verbal communication, with a particular interest in language, framing, and what people reveal through the words they choose. I am not an attorney, a psychologist, or a psychiatrist, so I'm not here to diagnose Elizabeth Siders, and I'm certainly not here to decide whether she is competent to stand trial. What I am interested is language, because sometimes two documents can be asking for something that sounds very similar, but the reasoning underneath them sounds completely different. And before we get into this, I want to say something very clearly. There are 16 children at the center of this case, and the allegations surrounding the conditions in which those children lived are extremely serious. Whatever we learn about Elizabeth, her mental condition, her history, whether she herself may have been abused, isolated, or controlled, does not take 1 ounce of suffering away from those children. It doesn't excuse neglect if neglect occurred, and it certainly doesn't erase harm. But these things are not mutually exclusive. A person can participate in harm and also have been harmed herself. A perpetrator can also be a victim. And if we are genuinely trying to understand what happened inside this family, I think we have to be willing to hold both possibilities in our heads at the same time. Now, let me show you what caught my attention. I want to start with Gary Siders Jr. I'm actually going to read this filing to you rather than summarize it, because I want you to hear the language for yourself. And this is only the motion to seal the medical psychological records, but listen to this language. It begins with, "Now comes defendant Gary Siders Jr. by and through counsel and respectfully moves this court for leave to file under seal defendant's motion for competency evaluation and the proposed entry relating thereto. Defendant's competency to stand trial has been raised, and the documents at issue concern defendant's present mental condition and request for psychiatric evaluation. The rest of it, and really indeed, I would say all of that is pretty much boilerplate. I'm not an attorney, as I said, but that's pretty much boilerplate legal language. You can just fill in the blanks, pretty much. So now remember that language. Gary Jr.'s attorney is telling the court that there are psychiatric and mental health materials relevant to the competency question and asking that those sensitive records be protected. That tells us there is mental health information that counsel believes bears on Gary Jr.'s competency. And that's basically where I want to leave Gary for the moment. Because now, listen to Elizabeth's filing for her competency hearing. It says, "Motion for an evaluation to determine whether the defendant is not guilty by reason of insanity and whether the defendant is competent to stand trial." It says, "Now comes counsel for the defendant, who hereby respectfully moves the court for an order that a formal evaluation be conducted in order to determine whether the defendant is competent at this time to stand trial to the offenses as charged herein. Alternatively, if the defendant is found to be competent, counsel hereby simultaneously requests that the defendant undergo an evaluation to determine if she is not guilty by reason of insanity, because she was suffering from a condition which would produce legal insanity at the time of the alleged offense." That's pretty boilerplate. Now listen to the memorandum in support. Listen closely to this. "As of the filing of this motion, the defendant has not been indicted, and therefore, counsel does not have all of the facts, evidence, or circumstances of this case or the defendant's subsequent arrest. However, in the interim, counsel has met with the defendant on numerous occasions and for extended periods. During these interactions, counsel has been able to observe the defendant's demeanor, conduct, and comprehension. These interactions led counsel to believe that the defendant may be suffering from significant mental health issues and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense. Counsel is prepared to provide a more detailed accounting of his concerns and the specific conduct giving rise to those concerns directly to the court and eventually to the evaluating medical professionals. At this time, counsel believes that the defendant's significant mental health issues would not only affect whether she is competent to stand trial, but would also have affected her ability to understand the wrongfulness of her conduct at the time of the alleged offenses, such that the defendant would not have fully understood the consequences of her actions at the time of the alleged offenses, should such actions have actually constituted criminal conduct. What her attorney is saying is totally different. It's more personal. He is saying he has met with Elizabeth numerous times. He has observed her for extended periods, and during those meetings, he has personally observed her demeanor, conduct, and comprehension. And those interactions led him to believe competency may be an issue. Ohio law allows the defense to raise competency. It does not require the defendant herself to be the person who first raises the concern, because the way this is worded, it makes me believe that her defense attorney raised this concern himself. It does not sound to me like Elizabeth and her attorney worked together to say, hey, let's say I'm incompetent to stand trial. Let's do that. I want to be very precise here. I do not know whether Elizabeth and her attorney discussed filing this beforehand. I don't know whether she agreed with him, and I don't know whether she disagreed with him. Really, I don't know. We're kept in the dark about a lot. And of course, this is attorney-client privilege. So those conversations are private. But what I can read is a document in front of me. And the document says that his observations of his client are what caused him concern. To me, that is very different from merely checking a procedural box. And frankly, it sounds as though something about those interactions bothered him enough that he believed this needed professional attention. Not that he has determined that she is incompetent. He hasn't, of course. And not that she is legally insane. We don't know that either. But enough that he is saying someone qualified needs to look at this. And then he goes one step further. If Elizabeth is found competent, he also wants her evaluated regarding her mental condition at the time of the alleged offenses. Ohio treats those as separate inquiries. Competency concerns whether she can understand the proceedings and assist in her defense now, while an insanity evaluation looks at whether, because of a severe mental disease or defect, she understood the wrongfulness of her alleged acts then, at the time. And that makes something her attorney said earlier much more interesting to me. Shortly, right after he became Elizabeth's defense attorney, he said Elizabeth does not consider herself a victim. And I've been thinking about that ever since he said it, because if someone has lived inside a particular reality since she was practically a child, would she necessarily recognize it as abnormal? Elizabeth was only 15 when this family life began. She became pregnant very young. She married very young. And then, year after year after year, pregnancy, childbirth, caring for children, another pregnancy, another postpartum period. I'm not saying pregnancy made Elizabeth incompetent. Absolutely not. I'm not saying repeated pregnancies caused whatever Scully believes he is observing. But medically, the period between pregnancies is supposed to allow for recovery. And the American College of Obstetrics and Gynecologists, or ACOG, advises avoiding intervals shorter than 6 months and counseling about the risks of becoming pregnant again sooner than 18 months. Postpartum care also specifically includes attention to emotional and mental health. So, when you're looking at a woman who appears to have spent much of her adult life pregnant, postpartum, nursing, or caring for a very large number of children, I don't think we simply shrug that off as a relevant background. And then we add something else: possible coercive control. Not proven coercive control, possible. Because listen to what people who knew Elizabeth before and during this relationship are saying. During Joey Russell's TikTok Live, Stacy, someone Joey recognizes as having known Elizabeth from school, describes the Elizabeth she remembers. Listen to this for a second.
And she wasn't like that as a teenager, a young teenager before she was with him. She was friends with everybody. She was a cheerleader. She was the one that was, when somebody was new and came to school and didn't have no friends, she was the one that would go and sit next to that kid. Everybody that knows Elizabeth growing up can attest to that.
That's interesting. Back then, when she knew Elizabeth, she said Elizabeth was friends with everybody. She was a cheerleader, the girl who would go sit with a new kid who didn't know anyone. That's one person's recollection. It isn't a clinical record. But then Stacy looks at later images of Elizabeth and says this.
It's like okay. The best thing that I could come up with too when I looked at her before picture when she was blonde, when she was younger, to now, it looks like he sucked the fucking life out of her. That's what it looks like.
Now, of course, that is her interpretation, and we should treat it as that. But she's describing a change that she believes she sees in someone she actually knew before this marriage. Then Joey, Elizabeth's brother, says something even more specific. Listen to this.
Whatever let us around her and Brooms and bad around her.
Quote, wouldn't even let us around her and brothers and dad around her. That too is Joey's allegation. We can't independently prove from that statement alone who restricted the contact, how much contact there was, or exactly why. But isolation from family is one of the things we pay attention to when we talk about coercive control. And coercive control doesn't always look like somebody physically locking another person in a room. It can involve gradually shrinking another person's world, limiting relationships, increasing dependency, controlling access to people or information, making the controlling environment feel normal. Again, I am not saying that that has been proven here. I'm asking whether it belongs on the list of possibilities professionals may need to examine. Because if you enter a relationship at 15, if that relationship becomes essentially your entire adult world, if your contact with your original family diminishes, if pregnancy and child-rearing dominate your adult life, and if whatever conditions exist around you become the only normal you've known, then when somebody later asks, why doesn't she see herself as a victim? I'm not sure the answer is necessarily because she wasn't one. It could also be because she doesn't know anything else. And that is where her attorney's later filing becomes so interesting to me. We don't know yet what happened exactly, but I think there's a larger question here that is worth asking even before we get those answers. What happened to Elizabeth Siders between the teenager people remember and the woman her own attorney is now asking professionals to evaluate? And can we consider the possibility that she may have participated in harming her children, while also considering whether something happened to her along the way? Those aren't comfortable questions, but comfortable questions aren't necessarily the useful ones. So, what do you think about the motion for possible insanity if they find her competent to stand trial? What do you think is going on in the case? What do you think about Elizabeth herself? And please remember, keep the comments respectful. And if this topic or my videos resonate with you, please like, subscribe, If you want to support the channel more directly, there are memberships available for special perks. So you just hit the button below and sign up. Thank you for joining me, and I will see you next time.